My name is Susan Frank, as some of you may recall from this morning, and I am here in my capacity as the Vice Chair for the Academic Council of the Institute for Transnational Arbitration. I have the joy to be pinch hitting for Andrea Bjorklund, whose plane we hope should be landing shortly. I hope that you've all had an opportunity to enjoy your meal and your lovely desserts, and of course we cannot go further without thanking the serious generosity of the sponsors of this luncheon, which include the Chartered Institute and its North American branch, FTI Consulting, and Interface Consulting. These three groups not only bring you delightful food, but also delightful conversation. I am quite seriously honored and delighted, although it is a bit selfish on my part, to be introducing Martin Hunter and Jarrod Wong. Martin Hunter, in a way, needs no introduction, but certainly deserves one. I use his book, Redfern and Hunter, to teach my own international arbitration classes, and he never ceases to educate us, including providing real-world experience and quotes like, "The check was in the post," from earlier today. But more formally, Martin was a partner in Freshfields for over 27 years and primarily responsible for the establishment of its International Arbitration Group. Upon retiring, he requalified as a barrister, he joined Essex Court Chambers, and he continues to practice in international arbitration. He also served as the International Dispute Resolution Professor at Nottingham Trent University, which is near and dear to my heart because it is where my husband actually graduated from, and he was appointed as emeritus there in 2010. But it's not just his work in the UK. He's also taught worldwide in India, in Brazil, in Budapest, and is largely responsible for the international knowledge transfer related to international commercial dispute settlement. And of course, he has other titles to his name, including being on ITA's Academic Council, the ICC Court, the LCIA Court. He was responsible for shepherding through the 1996 English Arbitration Act, which I commend to my students to read as a better version of arbitration than we have in the United States. So I think that we all owe him a very great debt, and I'm looking forward to his fireside chat with my colleague Jarrod Wong. Jarrod is a professor of law and the co-director of the Global Center at the University of Pacific McGeorge School of Law in Sacramento. He is probably best known as a scholar related to international investment law, having published in the Minnesota Law Review, Tulane Law Review, George Mason Law Review. He has a piece coming out in the Columbia Journal of Transnational Law, if it hasn't already been published, on the meaning of, I think it's ICCIT Article 25, if I've got that correct.
State-to-state investment arbitration.
Yes, so Jarrod's quite prolific, but he also is good in commercial arbitration too. So we're very lucky to have him conducting the interview. He has law degrees, first-class honors from Cambridge, Berkeley, Chicago, you name it. And like various people within this room, has grown up within the broad reach of the Institute for Transnational Arbitration. So I now turn the conversation and the fireside chat over to Jarrod to continue our tradition of conversation with international arbitration luminaries during lunch.
Fabulous. Thank you so much, Susan, for those kind words. I'm delighted to welcome you this afternoon, particularly now that you've been fed and fed well. Our conversation with Professor Martin Hunter is part of the ITA's Oral History Project, where the ITA, under the leadership of the Academic Council, is attempting to capture the stories and the histories of the most eminent arbitrators in the world. And I'm especially grateful to Martin for agreeing to add to what will surely be yet another fine chapter of this project. I should also mention that, time permitting, we would like to open the floor to questions. So please, if they occur to you along the way, hang on to them, and we'd like to hear from you at the end. I know that Todd Weiler this morning was already threatening to ask a question about Martin's latest technological toys, but I will hope that this room has more pertinent questions. Susan has already mentioned this, but I'm going to summarize it again. But Martin was head of the International Arbitration Group of Freshfields, having worked there for 30 years, from 1964 to 1994. In 1994, he re-qualified as a barrister and joined Essex Court Chambers in London, where he continues to practice as an international arbitration specialist. The following year, 1995, he was appointed to a chaired professorship of international dispute resolution at Nottingham Trent University, where he is now emeritus. Martin has also served as an arbitrator in numerous cases, including as the chair in a number of high-profile NAFTA cases. And he is also, of course, co-author of Redfern and Hunter on International Arbitration, referred to in some circles as the Red Bible of International Arbitration, even though it has since then...
I think it's blue now.
Right, taken on a distinct shade of blue in the meantime.
But the main author now is Constantine Partasides and Nigel Blackaby. I don't know if they're here. If Constantine, was here this morning. Go on.
As I think we all know, this biographical excerpt represents just the tip of the iceberg. I think what strikes one in surveying the very breadth and depth of your involvement with international arbitration is that you've inhabited every conceivable role: solicitor, barrister, arbitrator, professor, author. Are these separate phases in your mind, or are they part of a package, of a grand master plan that you've had?
I wouldn't call it a master plan. I wouldn't pronounce it that way either. I would call it a master plan. But
Or that.
But no, no plan. It's all a mix of coincidence, accident, and most of all, luck. Being in the right place at the right time, through happenstance. I promised I wouldn't talk about sailing across the Atlantic, but the reason I got asked to do those arbitrations in Kuwait, not Aminol, 10 years before Aminol, more than 10 years, was because I was the latest guy who'd come back from law school and had a clean desk. And I got a call from the senior partner, Sir Charles Wishaw, who incidentally was the lawyer who wrote the Aminol concession and was the Sheikh of the ruler of Kuwait's personal lawyer. And he said, "You're the guy with the cleanest desk in the office because you've just come back from law school. Would you agree to being seconded to the dispute resolution department, what in America you probably call the litigation department, in order to help Alan Redfern with these cases?" And two cases, one against the government, Tariff versus Sudan, which is incidentally in many ways more famous than, it was about the high dam in Sudan, many ways more famous than Denora versus Kuwait, which was the other case I had to do. Sorry, carry on.
And so this was then your first introduction to Redfern, which then led to, of course, the Redfern and Hunter volume on international arbitration. And we are now at the threshold of a 6th edition of the book. And I think for many of us, it served as our introduction to international arbitration, and we could not have gotten a better introduction. In fact, there is a review that I would like to quote from the Cambridge Law Journal in 1992, which starts off in this way: "There are only 2 really good books to be had at the moment that survey the whole range of international commercial arbitration. Easily the best is this 2nd edition of Redfern and Hunter. Second best is the 1st edition of Redfern and Hunter."
You're joking.
Can you tell us how this book came about and what the book has meant to you?
Well, I do remember that. I don't think I ever saw that review. I happened to be doing a domestic arbitration, one of the few I've ever done, between an author and a publishing house. I'd been appointed by the publishing house, and the other arbitrator was another author. And while that arbitration was going, I was called by somebody from Sweden Maxwell, who said, "Oh, we're being outgunned by Butterworths," which was Mustel and Boyd. Those of you who know enough about England to know that they were the absolute gurus of domestic arbitration, and they said, "Would you try to read Sweden Maxwell? We're feeling we're being outgunned," and I said, "Well, you are. Definitely, you are. Would you write a competing book?" And I said, "No, I wouldn't dare." Michael Mustel, who subsequently became a law lord, and Stuart Boyd, who was a good friend, and well, they're both good friends actually. I couldn't possibly have competed with them. So I said, "But they don't know anything about international arbitration. I could attempt a book on that." And they said, "Good, do a synopsis and let us know." And that's how it started. And the other thing that I should say is that I very soon realized I couldn't do it on my own. So I went to Alan Redfern, who it wasn't any longer my boss because I'd become a partner. And so we were partners and very good friends, still are today. And said, "Alan, do you think we should do this?" And he said, "Yes." So we did. And that's how it came about.
That's the genesis of the great book. It's a little ironic, though, that it originated in a domestic arbitration, which from our prior conversations, I know that doesn't interest you anywhere as much as international dispute resolution.
I have no interest in domestic arbitration. It's a subset of national litigation, and is always treated as such because in the English context anyway, everybody in the room is English, almost by definition. English parties, English counsel, English arbitrators. Why should I be interested in that? It's like, it has no cross-border angle to it at all.
And what's so interesting about cross-border angles? What sees your...
Well, I thought you'd know that.
But we want to hear from you.
Well, don't forget, I'm talking about the immediate period after the instrument which created international arbitration, which was, hands up anyone who knows? New York Convention, 1958. Before that, okay, they failed in the 1930s with the Geneva Protocols, the Geneva Conventions. It just didn't work. Why? Because you had double executor translating the French into English, and it just wasn't what was needed. It was a disaster. And it was only after the Second World War when a number of geniuses, genii, I suppose, but you know who I'm talking about, the great Peter Saunders, who died at the age of 100 a couple of years ago, who was absolutely one of my heroes. I'm getting emotional now. And so it was the start of the whole thing. And by 1964, when I joined Freshfields, no, I joined it in 61, 64 when I became qualified, nobody had heard of the New York Convention. And that was the foundation stone that created cross-border arbitration as we know it today. Without that, it's nothing. And still isn't. Hans van den Berg, he's now the successor to Peter Saunders.
Yeah, I think
I'm talking too much. I told you you'd have to stop me.
I find that I'm fascinated by the fact that we are the beneficiaries of your expertise through serendipity. I mean, you talked about having no master plan. That's certainly true. But you weren't even supposed to be working on international arbitration, and when you were, it was supposed to be temporary, wasn't it?
Yes.
What happened?
Well, this meeting in the senior partner's office, where he'd introduced me to Alan Redfern, he said, "Okay, you may go now. Alan will." I said, "Yes, I'll do it if that's what the firm wants." Well, only one does say that, doesn't one? And,
What a job, yes.
and I got halfway to the door. He said, "Do you have any questions?" And I said, "No." I was very overawed by it all. And I turned and said, "Yes, Sir Charles, I do have one question. How long, this is a secondment, is that correct? From corporate, where we're supposed to be." Thank God I was not still there. And a secondment. And he said, "Yes, it is." And I said, "Well, how long is it expected to last?" And Sir Charles said, "I don't know, I'll have to ask Alan Redfern." And Alan said, who was 3 or 4 years older than I am, he still is. And Alan said, "Well, I don't know either, but if I have to guess, it'd be not less than 6 months and not more than 1 year." It's a sensible thing to say with 2 arbitrations on the table. And I told that story 27 years later. No, more than that, 30, because I wasn't yet a partner. 30 years later, I told that story to the Dispute Resolution Department, my friends there, and said, "Of course, you do understand, don't you, that I'm only on loan from the corporate department."
There we go. So clearly this meeting with Redfern and then your introduction to international arbitration represents one of the landmarks in your career. Presumably you would say that becoming a partner too at Freshfields was another landmark.
Yes.
What was that like, being at the forefront of this new practice and trying to figure everything out?
Well, it was like that, trying to figure everything out. Meanwhile, we'd then, as always happens, you know, I'm sure all you people with your clients are the same, but I used to go to Kuwait once a month at least to collect evidence on the on the initial case. And then gradually, I must have had a portfolio of 10, 15 cases, which arose from the, I'm just trying to get the right word. I don't like it with a microphone around my neck, but arose because the Kuwaitis were brilliant, but stupid at the same time. Don't forget, Kuwait had been a desert until after the war, the 1945 war, 40 to 45 war, and they found the oil there in the 1930s. They didn't start developing it until the 50s. By 1964, it had exploded. And they said, well, every contract we do to have things done in Kuwait, we'll need to put them out to tender. So they all nodded, and they did that, and they put it out to tender. And of course, they got a bunch of, I better not mention any nationalities, but from the southern part of Europe mainly, who bid low to get the contracts. And then their philosophy was get contract, set up hut on site, start preparing the claims. And the poor sod who had to handle the claims for the defence was me, because Alan Redfern by then was managing partner of an expanding dispute resolution department, and I was the guy who dealt with the international arbitrations. It was fun, I enjoyed it, but there were some extraordinary cases.
Well, because this was also new, and we were just referring to domestic arbitration a moment ago, was there any tension between those who wanted to develop this international practice at Freshfields and then those who wanted to keep to, a more conventional local litigation model?
I don't know, but I don't think anyone knew it was happening. I'm not sure that I knew it was happening, except other than by looking back. I mean, I only see it now, clearly, as that's why I told you in our Skype conversation that for me, all this was just happened. There was no... I lied to you in one respect, not not deliberately. I suppose if it's a lie, by definition, it has to be deliberate. But it was an it was an inaccuracy, and that was that I had no plan. Well, that was true in a way, but it's also true that I had, after I left Cambridge, I had a theory that the way to have an easy life in the law, the practice of law, was to become a specialist in a very, very small emerging discipline. I guess that those of you who are, who on earth had heard of energy law in 1955, 60, 65 even? It just wasn't discussed, was it? I mean, there were some oily lawyers, and I was one of them, I suppose, because I worked in Kuwait. But you didn't have Houston and all that, I don't think, being a kind of world centre of energy law. I'm actually not sure what energy law means, but that's because I'm not in energy.
So after all of this excitement, what did you do? You decide to leave it in 1994 to become a barrister?
That's too long a story to tell. But there were a lot of reasons. One was that I wanted to be my own boss. Law firms are changing. As a partner, you thought you were your own boss, but you're not really. Hands up those who are partners of law firms and think they're their own boss. Not a single hand. You're not in a law firm. And barristers, you are literally a sole practitioner working out of a thing called a chambers with all the support you need in terms of secretarial and all of that kind of stuff. And it's perfect. I've been doing it now for 20 years, and I have no plans to give it up. And where was I?
Talking about why you became a barrister?
Yeah, well, that was the main reason. But the reason I left Freshfields was that I just hired in the thought that he would be my successor as the head of Freshfields International Arbitration Group, a very bright young man, who still is. His name is Jan Paulsen. But he's not a very good number two. He gets sort of edgy if he's not the head of the group. So I said to Jan, I think it's in everybody's interest that I should go. And so I did. And that's why I took my pension and went. And I had a good time the last 20 years.
Quite
I'm
clearly.
not quite sure what I'm going to do next.
Well, as if the challenge wasn't enough, the very following year you got appointed as a professor of international dispute resolution at Nottingham Trent. So what happened there?
Well, it's a chap called Nigel Savage, who's an amazing. By the way, Nottingham Trent, most of you people wouldn't know what Nottingham Trent is. And it was a polytech, what we call a polytechnic. Do you have polytechnics in America?
Yes.
Yeah.
We do.
You're
We
about
do.
to say no.
Well, I didn't grow up here, so
No, I know.
I'm going to trust my
I
audience.
don't think they have them in Singapore.
They do, actually.
Do they?
Yeah.
But polytechnic is a technical college which taught people skills. How to be a bricklayer, how to service automobiles, that kind of thing. And the people there were amazing. And I learned my trade as a teacher at NTU. It's a super place. It all came about that, by the way. I'm sorry, I'm going on talking so much. Margaret Thatcher, it was the heyday of Margaret Thatcher, and she thought that the Brits were undereducated, correctly, at all levels, from the top to the bottom. And she said, I want to give the polytechnics the opportunity to become full universities. And Nottingham Trent and Oxford Brookes, and I don't know, 6 to 10 others around the land were given this opportunity, and most of them succeeded very well. And Nottingham Trent, the motto at Nottingham Trent is that the best lectures are when the professor sets it all up, sits at the back of the class, and the students teach themselves. And of course, it's not far from what organizations like NITA do. You know, the students at NITA, any of you involved in NITA? I was for a while. And, but the concept there is that the students teach themselves. And that's what I do now around the world. I go and sit at the back of the class while the students teach themselves. I create case studies and things like that for them to do. Sorry, I'm talking too much.
No, not at all.
I told him that he would have to, his big problem today would be to shut me up.
Not at all. I think in progressing through these various roles, in this march of time, I mean, has your perception, conception of what international arbitration should be and how it should be practiced, has that changed? Or, well, I guess
Yes.
maybe in what significant way has it changed?
Destroy this nasty thing around my neck. No, I think a lot of the stuff that was said this morning by Constantine and yesterday by the group that were talking about, can't remember what it was now, but practice in this kind, I am worried that there's a certain level. I know that if I use the word corrupt in the United States, you immediately think of, well, nobody's being bribed. Personally, I think the word corruption is much wider, much wider than bribery. I don't think that arbitrators are bribed. What I do think, how many of you have read Profiting from Injustice? Do you agree with it? Do you think it's got a grain of truth in it? I don't agree with it. It's journalism at its almost at its worst. Not quite. It probably needed to be said, and of course it's like jury trials, isn't it? You need to do a certain amount of exaggeration to get the jury to listen. Never use, I'm going to digress for 10 seconds. I've had American attorneys many, many times sitting in front of me in international arbitrations. American attorneys who say, from thereafter, the respondent's contact was egregious and outrageous. And so I write down. I say, just a minute, I'm anxious to not to miss anything. Can you tell me the difference between egregious and outrageous? Because I need to know. If I'm going to listen carefully to the presentation you're making on behalf of your client, I need to know why outrageous is different from egregious. And of course, you can imagine they go, whoa, 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 and then they turn to somebody else, and the answer is exactly the same, aren't they? Well, can anyone suggest a difference?
Not all your interactions with American attorneys have been so unfortunate, right? Think about the Amin Oil case versus Kuwait that Constantine was talking about today, for example.
Brilliant, brilliant, brilliant exposition, by the way.
Yes, it was. An additional nugget, though, of history is that on the other side of the table was Bill Owen.
Yes. Great man.
Yes.
Texan.
American attorney.
Totally honest.
And a founder of ITA, by the way.
I didn't know that until this morning.
And what was your interaction with him like?
Perfect. Alan and I knew we could trust him every inch of the way. Can you do that with the other side in certain other countries? You can't. I don't think you can. But they're representing the clients in the way they think they ought to be representing their clients. Now, you can understand that too. However, go on. I'm going to get onto dangerous ground in a minute if I'm not careful.
Well, that's, I mean,
You wouldn't mind, would you?
Not at all. I think it'll make it more fun. But more seriously, though, I think given the spectacular vantage point that you have, I mean, we truly are the best place to collect and hear about your thoughts on international arbitration, its various cross-currents, you know, and essentially kind of what lies ahead for it. And one of the debates, I guess, swirling around is whether arbitrators in investment disputes should be more concerned, you know, with developing the law or with resolving the particular dispute in front of them. Should they be concerned about, or is there a phenomenon of common law-nizing international arbitration? And is that a good thing or bad?
Well, I don't really think that arbitrators should be setting precedents on the law. It's a personal view, because I think one of the reasons originally for commercial parties to have their disputes resolved in private by arbitrators was that they wouldn't have to apply precedent. And let's face it, in the continental systems, civilian law systems, I suppose, how many, hands up, how many civilian lawyers have we got here? 1, 2, yes.
It's not a bad number at all.
Yeah. I'm actually surprised that there's so many. I always ask every class I teach, you know, how many of you are civilians and lawyers and how many are you common lawyers? And my class next week in Miami will be, interestingly, will be about 50-50. And I divide them into teams. You're the plaintiffs, you're the claimants' lawyers. And I've always put the common lawyers there. And you're the respondents' lawyers. And it's very interesting to see how, you know, they approach it differently. And precedent is, well, as you know, in the civilian legal systems have very little adhesion. And that's good, because arbitrators, I think, have to decide every case. And I think to be stuck in handcuffs because Charlie Brower or somebody has decided that a certain way 3 weeks ago or last year is actually not useful. You agree with that, Todd? I can see you nodding. Yeah. And I think one of the advantages of the international arbitration scenario is that you shouldn't have to follow precedents. I mean, there are obviously, as there are in the civilian systems, there are propositions of law where previous decisions can inform. But the idea that they're binding comes from England in the Middle Ages, doesn't it? I don't know. I was going to say something else. No, you better take over again.
No, just wondering, what about the cost, though, of uncertainty that flows from the fact that there is no precedent?
But isn't there uncertainty? Does precedent solve the problem of uncertainty? Come on. Where have you been?
Clearly not taking a class with you. My great misfortune. I think that's, I suppose, one of the concerns to raise, and people debate this question, is whether arbitrators may be taking a heavier hand than is necessary in order to advance his or her reputation. And a related question might be one of dissenting opinions. And I know that you worked on an ICC commission that spoke to this very subject. What's your view of dissenting opinions?
I think I differ from my colleague and friend Alan Redfern on this, because he thinks they're awful, and he made a big presentation about it. I actually think they're, in the right circumstances and for the right reasons, they're useful. And I mean, in the Aminol case Constantine was talking about this morning, Sir Jarrod Fitzmaurice's, he elegantly called a separate opinion, but in fact was a dissenting opinion, was very interesting. I think he was wrong, actually, but then I shouldn't say that Sir Jarrod Fitzmaurice was wrong, because he's one of the greatest jurists in the last 100 years. President, International Court of Justice, all that. Great public international lawyer. I'm sidetracking myself at the moment, which is usual for me. But I would are you going to let me say something about third-party assisted negotiation?
Absolutely. Now would be a good time since you bring it up.
Okay. I just don't want to miss, because we must be running out of time.
No,
right?
we're fine.
Oh, okay. Yes. We've had quite a lot talked about, well, has arbitration had its day? International arbitration had its day. And I agree with Constantine that a lot of thought and action needs to be injected into the process at all levels: arbitrators, institutions, parties' counsel, in order for it to survive. And why do I say that? Well, because you ask, how many corporate counsel we got here, in-house counsel? Okay, now, are your bosses worried about the expense and time taken by resolving disputes? Rightly so. I think so. They go on for years. The only people who get rich out of it are the arbitrators and the council, usually just the council. I think that there's got to be a fundamental change of attitude by the legal professions of the world. It's mainly in the common law, so it comes from the common law side. But I think we've got to have a fundamental change of attitude in order to make international arbitration more acceptable to people like my friend here, who nodded a couple of times, the corporate counsel. It's getting out of hand, isn't it? Yes. And I think what's going to happen, and this is a positive development from the United States. I don't know whether any of you have heard of or had anything to do with PON, the project on negotiation. It was originally called at Harvard University, which was the great Roger Fisher. You know the book, Getting to Yes? And brilliant stuff. And Roger Fisher, I did know him slightly, only because I was introduced to him by his successor, who's called Professor Bob Mnookin at the Harvard Negotiation Project. Oh, you know, I must talk to you about it later, because these are the guys who can save our souls. The lawyers won't be pleased because they won't make so much money. But the idea that, which is coming up in your industry, the oil and gas industry, energy industry, is coming up that in long-term gas supply contracts, for example, that the arbitrators can, of their own motion, assume power and jurisdiction to rewrite the parties' contracts, for me, is a heresy. You'll say I'm old-fashioned, and I have a couple of friends who say, well, Martin, you're just not at the cutting edge. And I'll accept that, but I think that the duty of an arbitrator under a contract with an arbitration clause in it is to interpret the contract, not to make the contract.
I think you're selling yourself short. I think you are really cutting edge, and this is related to that 2000 lecture that you gave at Nottingham, where you talked about how, in predicting the future for international arbitration, we are going to see more dispute management specialists as opposed to dispute resolution
so.
experts. What did you mean, and do
Well,
you think that has come to be in the last 15 years?
It hasn't come about, but I can see it. Every international arbitration institution around the world now is buffing up its mediation rules. You look at it, ICC, LCIA, AAA, ICDR, they're all doing it. Singapore, the whole lot. I think they've got a strong sense in here that their future as institutions is geared more towards, well, let's call it mediation because it's a word that people seem to I don't call it that. I call it third-party assisted negotiation. And indeed, the Harvard Negotiation Project is, they never use the word mediation, or hardly ever do. They talk about negotiation. And I think, I was a working professor of international dispute resolution. Still think of myself as that. And there are 3 levels of dispute resolution, aren't there? There's negotiation, direct negotiation between the parties. There's a third-party assisted negotiation, which you would all mostly call mediation. And there's arbitration, where somebody gives a binding decision. Now, you know, whether you're comfortable about giving the arbitrators power, jurisdiction, to make contracts between the parties, is up to you. Personally, I don't like it. I don't think it's their job. That is the job for a mediator or the third party who assists the party to bring the parties together. Because what we're talking about in business is the possibility of doing future business together. If you are, oh my God, can I tell one story?
Yes, but let me chime in here a little bit. I think what's remarkable about your article is not just that it embraces mediation, but that it advocates something that's even more sensitive to business interests, which is to create bodies that will supervise and detect disputes before they even get to the stage where they require mediation. And that is a trend that we will be seeing more of. And
I think so.
that will displace international arbitration in some respects.
Yeah, I mean, there are some disputes, particularly where there are governments involved, where nobody on the government side has the authority to do a deal, to settle a case. In not Aminal, but another Kuwait case, one very senior official, but not a politician, not a member of the ruling family, I said, I was conveying a message to him from the lawyer on the other side, which was an offer to discuss settlement. And this guy, his name was Faisal Mazidi, who's a very good friend, he laughed at me. And he said, Martin, if I agreed to settle this case, the newspapers are going to be all over me. The rulers of the country are going to be all over me. There's nothing. He said, look, get me a decision from the arbitrators, send it to me, and I'll take it down to the Ministry of Finance and they can write the check. I don't care whether we win or lose. We've got plenty of money. Well, they had. But to ask him to settle a case is putting his head on the block. Now, you see it its starkest in the government scenario. You can also see it in corporate scenarios, because nearly all big disputes between corporations. I've got somebody's back there.
Derriere, shall we say?
Jarrod, on the line. His job or his future promotion prospects, all that, depend on a positive outcome or an acceptable outcome to that particular dispute. It's just like my civil servant guy in Kuwait. You know, they'll be all over me if I agree to settle a case. Just give me a bit of paper, and I take it to the Ministry of Finance. I wanted to tell you one story about. I went to his memorial service. A man called Dennis Morris, chairman of Capital and Counties. It was a very, very big UK property firm. And his opposite number and another were playing in a golf day together. This is absolutely true story. It emerged that they were both being troubled in their respective positions by stuff coming up from the executives about a dispute between their two companies. And it was actually my old firm, Freshfields, that was on one side, and I think it was Linklaters on the other. I don't know, but two major firms. And they discussed the thing on the golf course and the usual lunch after it. And they said, why don't we get rid of the bloody lawyers? And you and I will settle down, sit together, and we'll solve this case in 10 minutes, won't we? It's only money, and it's money that's handleable for us. Neither of our corporations are being in any way threatened by the result of the case. And they agreed on that. They fired the lawyers. Well, actually, they just told them to keep out of the thing for a bit. And they settled it within a week on the after the golf course thing. Now, Pache, Constantine and others, you know, that's not a bad way of settling disputes, is it? Now, that's not mediation. It's not third-party assisted negotiation. It's happenstance, accidental negotiation, you know, on a golf course in an environment where both these two distinguished guys, chairman, they were interested in the future business that we're going to do between those two corporations. Sorry, I'm going on again.
No, not at all. You know, this, much like your introduction to international arbitration, clearly brings much benefit. But I feel I've been monopolizing all the questions, so shall we hear from our friends?
Yeah, but nice, wouldn't it?
Yes.
God.
Not about technology, please. Go
Would you
ahead,
like
Tom.
to connect me to the internet here?
There's a microphone over this top.
Do we have a... Go. Yeah.
The answer to your question is that egregious is an objective standard, or as outrageous is subjective.
Oh, interesting.
Oh, there we go.
And so my question is, could you tell us about some of the colorful characters you've met in your time, with or without names? And or perhaps with, you know, you could use pseudonyms, perhaps. And then a follow-up, which is related, would be, is there any difference in the pleading styles between British, or English, Canadian, American, New Zealand, or Australians?
I think the Australians have the best lawyers, best practitioners, with a tremendous work ethic and tremendous ethic, too. The United States, I think, the legal profession is dominated by the jury, the existence of the jury in civil matters, which I think is extraordinary. How on earth anyone can advise any responsible lawyer can advise a foreigner, a non-American party, to go and to sue a large American corporation in the courts in America, in the USA. Microsoft, was it Microsoft or Apple? Samsung took them on in California. Guess which side won? Well, the lawyers won, yeah. But by the way, do you have to be a US citizen to sit on a jury?
Yes.
Wonderful. Very, very, very impartial in the, isn't it?
Well, they're not deciding disputes relating to international arbitration.
No, but they're deciding disputes between American corporations or American parties and foreign parties. Jurors, do they have to read and write? Yes, ours do now. In the old days, the justification for these things being oral proceedings was that jurors couldn't necessarily read or write. At least you don't have that problem here. Oh, of course, if we're in Texas, it's not really the USA, is it?
Ouch. Yes.
Martin, you've done a lot for the future generations. I mean, building out of Freshfields, the assistants that have come through and grown up with you. But looking forward to the future, could you talk a little bit about this passion you have for India and this remarkable story of what's going on the East Coast over there?
We're off topic a bit, aren't we? But I'd be happy to.
That's a big part of your work, I don't think so.
Hmm?
That's a big part of your work.
Oh, part of my work. Well, it's not my work as a lawyer. Now, I happened, just by chance, which everything else in my life is by chance, to come alongside a wonderful man called Dr. Achyuta Samanta, Achyuta Samanta. Google him, please. Who is the most extraordinary human being I've ever met. He's this high. He was born in poverty because actually they weren't tribals, because you and I know what we mean by tribal. But there were 8 children, and the father was killed in a road accident when this one, who was almost the youngest, was 4 years old. And he's now, in theory, a multi-billionaire because he owns a vast tract of land in this estate, which is right on the east coast, south of half an hour's flying south of Kolkata. I had the good fortune to be introduced to him and asked by him to help him start a law school at his university. The reason he wanted that was not because he was particularly interested in law or law schools, but he'd been advised at bureaucratic level from New Delhi that his institution, which was an institute of technology, sort of polytechnic, I suppose, couldn't become a full university unless it had a wider selection of faculties or schools. And he'd been given ideas of a number of different schools. We now have 22 schools in the university. But the one he wanted to establish, because it sounded right to him, was a law school. And he went to ask a politician friend in New Delhi, how would he start a law school? And the politician said, I don't know, but I tell you what, my son is the current research assistant to a mad English professor, namely me. And the son brought him to our house outside London, and My wife and I both fell in love with him. He's the most extraordinary man. He's the present, he's the 21st century emanation of Mahatma Gandhi, I think, without the negative side of Mahatma Gandhi. And brilliant man. And that's how I came to be in Bhubaneswar, which is the capital city of Orissa State, as you know. I'd love you all to come there. Jan Paulsen, who is not an emotional guy, you know him, don't you? Most of you? Many of you. Certainly Dev does. Very well, don't you? And he's not an emotional guy, is he? But he accepted my invitation, he and Mariko, who's half Indian, to come to Odisha State weeks ago. Well, it was late November. Where are we now? January.
Mid-January.
So it's weeks ago. And apparently he's going around saying, you know, you've got to go to Martin Hunter's place in the east coast of India. He said that to you, didn't he?
Yes, he said that to me, and I've never seen him more animated.
Yes.
The image was he walked out onto a stage because they just said, come and sit down, and 25,000 students, children,
22,000.
22,000. That's the scale at which you're dealing.
Yes. And they were born under the trees, literally. And now they're being educated. His, Dr. Samantha's thesis is, which was Mahatma Gandhi's, elimination of poverty through education. Handouts don't do anything to solve the problem at its source. And the elimination of poverty worldwide is possibly the biggest issue that's confronting the human race today. Possibly, I don't know. I mean, there are others, but the problems that lawyers face are peanuts compared with in Africa, Latin America, particularly Brazil, the Amazon Delta, and in India, where there's still a 30%, roughly, population of tribal people. And when I say tribal, I mean born with nothing, born under the trees. Good.
All right, I see David looking really nervous, so I'm afraid that's going to be all.
Not nervous at all. Appreciative for a wonderful insight into a special experience in the world of international arbitration. Thank you Jarrod for leading this interview, and Martin, you've honored ITA and IEL by allowing us to honor you. Thank you very much.
Thank you.